We're going to be talking about exploring long-term care, Medicaid, and asset protection. So a little bit about me for those who don't know me. I am 25 years as an attorney. I'm admitted to practice law in the United States Eastern and Southern districts, and I am also admitted in the United States Tax Court. I have a Juris Doctorate from New York Law School, and I went back to school since I loved it so much, and now I have an LLM, which is a Master of Laws in Taxation. I've served in many government agencies, including as an assistant district attorney. I was an administrative law judge for the city of New York. I was an attorney for the NYPD, and I ended my city career as a managing attorney for the New York City Department of Buildings. My firm is a general legal practice firm that focuses on elder law, wills and estate planning, corporate and individual tax matters, probates and administration. I do real estate. I do business formations, and they also have a pretty decent tax resolution service as well. So people who get letters from the IRS and get the scary ones on New York State, I try to help you with that as well. So what is the goal of the presentation? The goal of this presentation is to allow you to gain insights and a bird's eye view of long-term care Medicaid. This way you can walk away with a basic understanding of the long-term care Medicaid system and learn about planning strategies to become eligible for long-term care Medicaid and to protect your assets at the same time. So some of the rules that I'd like you to adhere to so I can make this a smooth presentation is first, please stay muted through the presentation. There will be an opportunity to ask questions at the end of the presentation. I do want to be able to cover everything, and sometimes I get into questions and answers, and I lose my place, and then the next thing you know, it's 2 hours down the road, and nobody wants to stay here 2 hours, not even me. If you have questions and you want to get them in before you forget them, please type it in the chat. I will go through them at the end. Also, if you're writing something out, please keep your personal or confidential details out of the chat. You don't need to overshare. Try to ask general questions. We want to protect everyone's privacy. So this is being recorded, and which is why I blocked everyone's picture out, and I'll end up posting this on my YouTube channel and through my website. If you want to get a copy of the slides, just shoot me an email. You're going to be getting a survey, probably not tonight, but tomorrow, or certainly by Friday, just asking you, kind of how I did questions. So I always like to improve and be better in my presentation. And as an attorney, here is my disclaimer. This presentation is designed to inform, not to advise. So don't rely on this advice. It's not a legal opinion. It's just to let you know what's out there. Don't use this to interpret any law or rule. Laws and changes all the time, so you want to be able to contact a qualified person like me and have a one-to-one specialized conversation. So with all the legal mumbo-jumbo out of the way, this is the agenda. We'll be covering the following topics. What is long-term care Medicaid? Long-term care Medicaid eligibility requirements, some key long-term care Medicaid terms, some allowable spend-downs, long-term care insurance, Medicaid asset protection trusts, the tax consideration of Medicaid asset protection trusts. There's been some law changes that you should be aware of, or at least I should be aware of to be able to explain to you. Estate planning comparisons, and other long-term care Medicaid strategies. And finally, we'll do a quick Q&A. So what is long-term care Medicaid? Long-term care Medicaid is a federal program that's administered by the state. It helps cover the cost of long-term care services for people who are in need of financial assistance and assistance with daily living activities, bathing and dressing. This type of care is often needed in nursing homes, assisted living facilities, or even at home with professional caregivers. Overall, all the basics that you're going to learn today is something that's good for across the board, but it's going to be focused in New York State. I am admitted in New York State, so I'm going to focus my the nitty-gritty rules on what New York says. If there is a difference in them or that you should be aware of, I'll try to point that out to you. So long-term care Medicaid, people are always confused when we talk about Medicaid, and I just did it, Medicaid planning. Long-term care Medicaid is different from regular health insurance. Okay, Medicare is typically covers short-term medical care like hospital stays. It does not pay for most long-term care services. So if you have Medicare, Blue Cross, Blue Shield, HIP, or other healthcare insurance, if you go to the hospital, it pays your hospital bills, your doctor bills, your prescription medications. It pays all of that stuff. Okay. What typically happens is either in your home or if you go into the hospital, hospitals are for emergencies. After that emergency is over, the hospital kicks you out, and then they send you to rehab or they send you home. You typically, and it depends on your insurance coverage, but typically your health insurance will cover your rehabilitation stay up to a certain period of time. Typically, it's about 180 days. After 180 days, it turns from health care into long-term care, and that's where long-term care Medicaid planning comes into effect. So either you have insurance, you have long-term care insurance, which I'll talk about, or you private pay, you pay out of your pocket, or you ask the government to pay, and that is long-term care Medicaid. In order to receive long-term care Medicaid, you must meet two things: medical eligibility and financial eligibility. So it's the purpose of long-term care Medicaid is to allow people with little financial means to meet their long-term health and personal care. Medicaid as a long-term care is set up for people who cannot afford to pay for their long-term care. And the footnote to that is, or the tail that wags the dog, if I could say, is that the government decides who can afford it. So we may feel I can't afford it. I'm locked up in certain stuff. I have certain assets that I've spent my entire life to build and to try to give to my children. But the government says if you are if you don't meet the thresholds, you have to pay out of pocket. So health eligibility is, can a person perform the activities of daily living? Do they need assistance? And there's financial eligibility. Do they have the ability to pay for your own long-term care? So health eligibility. Again, this is New York. It's pretty universal around. These are generally what we look for. There's two types of daily living. There's activities of daily living and instrumental activities. Your activities are really associated with physical ability. Can you bathe yourself, go take a shower alone? Can you get in and out of a bed or a chair? Can you walk around? Can you use a toilet? So I'm from Brooklyn, so maybe I should say turlet, but those are the stuff that you look for. Can you eat on your own? Instrumental activities really deal more with mental incapacity, although some overlap. Can you prepare meals? Can you manage your money? You understand what you're doing when you're shopping for grocery or personal items. You know how to use a telephone, etc. So those are the type of things that what we look for. If you're deficient in one or more of those activities, then you need help. Okay, you either need an aide to come to your house to help you, or if it's severe enough, unfortunately, you may have to end up in a institution. Medicaid, once you satisfy the other prong, which are the financial eligibility, Medicaid will see if you have health eligibility, and they'll send someone to the house to do an evaluation. So this is a simplified financial eligibility in New York State. It changes every year. Typically, it's updated every year. The numbers you see here are not for a home health aid, but they're for facility care. There are different standards for each. I'm just right now spotlighting facility care as what you need. There's two things that they look at. Medicaid in your evaluation looks at what is your monthly income and what is your assets, so your hard assets. So if you're a single person applying Medicaid, you have to earn under $1,732. That's in 2024. If you're married and both people, spouses are applying, it's, almost double. It's 2,351. Typically, when it comes to income, we don't worry too much about getting you to the limits. Okay, there are some simple ways where we can get your limits. So if you have an IRA or you're getting a pension and you're getting Social Security and you're having your mandatory distributions, you some people never get to or below the $1,700. They would never will because they're getting their mandatory distributions and Social Security. So what happens to those people? There's something that we can put you in is called a pooled trust, or you also hear community Medicaid. What that is a charity that runs the pooled trust. You put the overage, so if you're making $6,000 a month, you're not going to get the 1,732, but we put the overage into this pooled trust. The managers of those pooled trusts use that money, that overage, that $6,300, excuse me, $5,600. They put that into pooled trust and they pay. So it'll pay for your rent, they'll pay for your utilities, they'll pay for your living expenses. So you're still having access and use of that money. It just doesn't stay in the bank, but it gets you immediately qualified. So we always have, whenever we deal with the government, okay, we're dealing with the old adage of whoever giveth with one hand taketh away with the other. So what they're giving you in one hand is putting it into the pool trust, using that money during the course of your life, and becoming immediately qualified, eligible for Medicaid. The he who taketh away is if you pass away, whatever left in those accounts goes to the charity who administers trust. Now, I get this question all the time. Oh, what's going to happen? Blah, blah, blah. And the answer is one, typically we don't find a lot of the money is left over because you're using that money on your daily activities, your regular living expenses. That's number one. And number two, even if they took $4,000 from me a month and I'm getting $7,000 of services, I think that's a great deal. I'm paying four and I'm getting six back. So going into a pooled trust to get income qualified is really to me, a no-brainer. You get the services and you're still using that money, you're sheltering. The harder, more difficult assets to work with are the hard assets. So this is not income. These are your, your home, your accounts, etc. Okay, here your assets as a single person is just over 31,000. If there's both married people applying, it's just over 42. If there's one, the applicant has the same number, the 31,000, and the non-applicant can have up to 154 and change. So those are the numbers that we're working with. In order for you to qualify asset-wise, you have to be at or below that number. If you're over $1 in income or you're over $1 in that, you're not going to get qualified. They're very, very strict with it. So here are some terms that you'll hear, okay? The first you hear is a look-back period. There is some myths with regard to it. It's people believe that if Medicaid isn't paying you during the penalty period, okay, excuse me, during the look-back period, you're paying Medicaid, okay, and that's not necessarily true. When you apply for Medicaid, you need to disclose all of your financial transactions for a period of time. Any transfer of asset or depletion of an asset that happens in that time, gifts, whatever, Medicaid is going to presume that you made that to become qualified for Medicaid. It's rebuttable, but if you never gave someone $100,000 before, and suddenly in 1 year, right before you apply, you give them $100,000, that's not going to pass the smell test in Medicaid. In New York and in most states, it's a 5-year look-back period for nursing care. They'll look at all the transactions in the past 5 years to see what happened and make their judgment. In New York, it's a 2.5-year look-back period. However, the caveat to that is the New York State Department of Health has informally stated, and it has delayed this 2.5 year look-back period until sometime in 2025. Okay, so that means as of right now, if you apply for home health aid, there is a zero look back period, so we can get all your assets out and get you financially qualified for that. You have to get um, your application in if that's something that you have. Very short amount of period of time. It's going to be very tight if you need to do that. New York State, bottom line, needs money, and the expectation in the industry is that this suspension will not last very much longer. It was initially instituted because of COVID, and it's been some time since there was COVID. So we don't know how or when. There's some talk about instead of instituting the full 2.5 year look back period, that's going to be staggered. The first year it's a year, and the next year it's a little bit more. But we don't know. There's no rules with regard to that. We'll have to play that by ear. But currently, as of today, it's suspended. There is a zero look back for home health aides. Some other terms you'll hear is a penalty period, which I alluded to before. The penalty period. This is the amount of time Medicaid will delay in paying a person's long-term care needs. So it's not that, as I said earlier, it's not that you pay Medicaid for the services during the penalty period. It's Medicaid will not pay for your services. So essentially, if you have $120,000 of cash in your bank account, and you want to go into a long-term care facility, the average cost is about $10,000 a month. It changes by region. You have $120,000. It's $10,000 a month. Medicaid, the penalty period is 11 months because it will take you 11 months to get down to the threshold. So that's what that's about. It's not that you're paying Medicaid, it's that Medicaid won't pay. The second portion of it is what people have is what you hear is the spend down. So if you have more than the threshold amount for Medicaid, you have to spend down your money to get to the threshold before Medicaid will pay. So that's the spend down is the amount of money you spend before you qualify financially. Here are some allowable spend downs. Accrued debt. You can pay off both spouses' personal and as well as your single loans, your vehicle loans, your mortgage, your credit card balances. Remember, you want to get value for your money as opposed to having to pay for certain things. So these are the type of stuff that you legitimately can pay to get you to the threshold balances. So you can pay them off. The purchase of medical devices not covered by insurance, eyeglasses, dentures, hearing aids, crutches, wheelchairs, all of that stuff. You can legitimately spend down and lower your assets. Home modification and repairs to improve access and safety. You can actually build a first floor bed or a bathroom. You can put those bars in the room. You can get the chair lifts. You can do a bunch of stuff to modify and repair your home to improve access and safety. You can repair a vehicle. Okay, so you can do vehicle repairs, tune-ups. You can sell an existing car at fair market value and purchase a new one. Typically, one car is an asset. You get a car that has the lift or handicapped accessible, or the whatever's that you need to assist you in that way. You can purchase annuities. Okay. Now, with regard to the annuities, the purpose is to become qualified. It's not to preserve the asset. Okay. The idea is if I eliminate a certain amount of money from my cash holdings in this annuity, it takes that money out. It's a lump sum of cash paid monthly to set income for the applicant and spouse. It has to be shorter than your life expectancy. The income is countable, but again, we have that pool trust. It's non-transferable, and like I said, Medicaid is listed as a beneficiary. So again, the purpose of it is to be qualified. The purpose of it is not to preserve the asset. And then there's the irrevocable funeral trust and prepaid funeral expenses. I like this, and people who've had consults with me in the past know I talk about this. So prepaying your funeral expenses is really good, in my opinion. You can pay in installments. as opposed to having your survivors have a $15,000 nut when you pass away and have to dig it out because the funeral home wants to get paid now. So you can spread your payments over time. You work that out with the funeral home. You go to any funeral home to get the policy, and you don't have to use that funeral home. So if you live in Marine Park and you use Marine Park Funeral Home to buy the policy, and then you move to Florida, when you're 65, as you're required to by law, then that policy will follow you, okay, to states to state. It locks in prices. So if you bought and identify a specific item like a coffin or a headstone or things of that nature, then that price is locked. So over the course of time, we know prices go up, but you lock in your price. And the final unintentional benefit is what we found during COVID, which is the funeral homes had backlogs of people waiting to be serviced, and the people who were taken first were people with prepaid plans in most cases. So the people in the trucks were less likely to be, people who had these prepaid plans. Some other allowable expenses is personal care expenses, including anything to assist you with your daily activities, and healthcare costs like dental, vision, hearing, health insurance premiums, prescription drugs, in-home licensed care aids, etc. All of these can help cut down your assets as allowable spend downs. This is not an exhaustive list. There's other stuff that we can do, but these are kind of the major ones that we see. I wanted to point something out to you because we spoke about spending down and using your funds to pay off your mortgage. So when you pay off your mortgage, you gain equity. Okay, so you have liability and you have equity. If you're single and you have no minor or disabled child, up to just over $1 million of your equity in your primary house is not counted in Medicaid. Okay, there is no penalty period as assessed to up to $1 million of equity in your primary house. So if you use a bunch of money to pay off your mortgage, you're gaining equity, so that can kind of offset it. So you really want to watch what you do. There is no limit if you're married. There is no equity limit if you're married or you have a minor or disabled child who lives with you. Now, here's, like I said, he who giveth with one hand taketh away. You will be eligible for Medicaid if your house is $900,000, okay? However, when you pass away or if you sell the home, Medicaid can seek reimbursement. So there can be a lien on the home. It will get you qualified, okay? But Medicaid may come a knocking at the end of the day. If your house is $2 million, the first $1,071,000 will pass without, and the counting will go off that. If you have if you have all equity and you want to cut down and your equity limitation, you can always take a mortgage, reverse mortgage to get out under the limit. So there's some flexibility, but I get these questions a lot when it comes to mortgages and equity of the house. So this is something to know. This is why you need to speak to someone who knows what they're talking about to try to figure out what really is your exposure and what you can do. When people come in to the office for a consult, in Medicaid, I always say the first line of defense is long-term care insurance. And I say that because long-term care insurance is the least restrictive, okay? It will pay for your coverage for in-home care, assisted living, and nursing care, depending on what your policy is. So I always tell people when you go to someone who does this work, who sells this product, when you talk to them about it, you should always ask them about the home aid deductible, because I've had clients who come to me who have these types of plans, and they give you a great price on facility care at the expense of a home care deductible. This one client had a $40,000 home care deductible. Majority of people come into my office would rather have a person come into the house and give care in that way, as opposed to having to go to a facility. So always ask that question. The average New York home care is about $80,000 a year on average. It's about anywhere between $28 an hour to $38 an hour. Typically, you're looking at a $350 a day period, cost per day. So those are the numbers you're looking at. When you're talking about full care, full coverage for an aide, we like to talk in terms of a 12-hour care. Obviously, the more time you put in, the more it's going to cost. The average facility care in New York is roughly $180,000 a year. So keep those numbers in mind if you're going to look for long-term care insurance, whether it's traditional or hybrid. So you know what's full care. You don't have to get full coverage, but if you only do $200 a day and you need $300 a day, you have to private pay the difference, not the insurance. So there are two general types of long-term care insurance. There's a hybrid whole life policy, and there's traditional long-term care insurance. The hybrid policy, a lot of clients like. The premiums are higher, but you have a death benefit. So if you have $1 million policy, it has a rider for long-term care, and you eat away your death benefit. And at the end of the day, if you have anything left over, that goes to your heirs, your beneficiaries. Okay. And if you never use it, then your beneficiaries get 100%. So some people are like, well, I'm paying a higher premium, but at the end of the day, I'm getting something back if I never go on Medicaid. Traditional long-term care insurance is more like car insurance or home insurance. So if the tree never hits your roof, or if you never get into an accident, you pay per month, but there's no payout. It's not wrong or incorrect for that to happen. Went too far. Or wrong or incorrect for that to happen. It's just that's how it goes. Your premiums are less. If you need to go on Medicaid, it will pay according to the terms of your insurance. And if you have to be a little careful with traditional long-term care insurance. Some policies can increase over time, and if it's long enough, some policies will in fact drop you. So it's when you need it the most, maybe it's not there. But make sure you have a nice conversation with your broker who deals with and sells these products, who can advise you on the different plans. So if you don't have insurance, or if you want to really get bulletproof, we can set up what we call a Medicaid Asset Protection Trust. So this is a special type of trust designed to help individuals qualify for Medicaid benefits while preserving their assets for their heirs. When I do these types of plans for people, I tell them Medicaid planning is not designed to help you. The purpose of Medicaid planning is designed to preserve assets for your heirs, not for you. You get restrictions. If you were by yourself, you would spend that money out of your pocket, get the best possible care for as long as you wanted to get it. The idea of planning is to allow your heirs to enjoy your hard work and the fruits of your hard work. So this Medicaid trust allows a person to transfer assets into that trust, which is then managed by a trustee. These assets are no longer considered assets of the individual. After the look-back period, they're exempt. Assets that are typically transferred into a Medicaid trust are homes, cash, investments, and savings. When I do Medicaid trust for clients, I never, or I shouldn't say never, but seldomly recommend you put everything in that basket. Because once it goes into that basket, it is very difficult to come out, and whatever inside cannot be used to the benefit of an individual. So you can't go to your Medicaid trustee and say, yeah, I want to go to Florida. I want to buy a car. Please pay that from the trust. That doesn't happen. So when we do these types of work, we work with people like in Serafino's office, and we try to figure out what are your cash flow needs, and we want to make sure you have enough assets and income coming to you that you can pay for your everyday living. So we don't want to put everything in, because once it all goes in, it's very difficult to get out. You can't be the trustee. Okay, typically we want someone else to be the trustee to be able to do that. I'll give you for instance, I have a client. They had a nice brownstone in New York, in Brooklyn. It's about $7 million. It was earning income, and they had 3 children, and they had $600,000 non-IRA exempt assets, cash, etc. So they wanted to make sure the children would be able to get their brownstone, without having to worry about a Medicaid lien, and they wanted to give each one of their children $100,000 at least at the end of the day. So we set up a Medicaid asset protection trust for them. We put in the house, and we put $300,000 of cash. Now that $300,000 cash did not just sit around. We had good investment advisors, as they're here today, as a few of them are, in Mariano's office, and other people. So we were able to get income from that $300,000, as well as the income from the rent rolls that were coming out of the brownstone. Income comes out, principal stays. Okay. And then on the outside, they had $300,000 of cash where they did whatever they wanted. Okay. They went on trips, they gave gifts, they paid for taxes, they paid for the lawn care, they did everything that they wanted to do. But they understood that $300,000 outside of the trust was subject to Medicaid liability. In fact, with those people, we did what I call the Cadillac plan, which is a Medicaid trust for the assets we spoke about. We did a revocable trust to avoid probate on the assets outside of the trust, and we also had one person on long-term care insurance. That's about as bulletproof as you can get when it comes to long-term care. It's a great plan if it's something that fits your model and what you need. A Medicaid trust is an irrevocable trust. It holds a person's asset. Once it goes into the trust, you no longer own them directly. Once the trust is made, it cannot be easily canceled or modified. The purpose of a Medicaid trust is to protect assets when applying for long-term Medicaid. By moving the assets into the Medicaid trust, they aren't counted. They're exempt from Medicaid once the look-back period expires. It's a great strategy for planning ahead and planning for future healthcare needs. Something I put into every one of my irrevocable trusts is something called a trust protector. Now, an irrevocable trust, as we just explained, is something that's irrevocable. It's very inflexible. We do with a trust protector, it's a third party. It's not the trustee. It is not the grantors or the creators of the trust. It's a third party, and they have powers that can advise or manage the timing of distributions. They can change or manage tax decisions. They can change terms in it. They can resolve disputes amongst beneficiaries. They can modify provisions through an amendment power that, remember, you can't modify and amend a irrevocable trust, but if you have a trust protector, that trust protector can. So as laws change, tax laws change, which I'll get into in a moment, how this came into handy recently, they can make those changes. If the trust rules change, tax rules change, they can do that. They can add or remove trustees or beneficiaries. They can construe terms of the trust to resolve ambiguity, and they can manage businesses. So if you have a child who doesn't want to manage the laundromat, your trust protector can handle the money laundering, the clothes laundering business that you have. So really good that all of my trusts at least have trust protectors, because in 2023, the IRS issued a revenue ruling that codified their position that irrevocable trusts do not enjoy a step-up in basis in property upon death, okay, if the trust property is not part of the grantor's taxable estate. So what does that mean? So that means if I bought a house for $100,000 and I sell a house for $1 million, I have $900,000 of gain. Now, there are exclusions. You add in, other factors to increase that basis, but I'm just keeping the numbers simple to be able to explain what's going on. You have $900,000 of gain. You have a capital gain that you have to pay for. You're taxed at that if you sell it while you're alive. If you inherit property, so you have your $1 million house, you give it to your children, and the day after you pass away, the children decide to sell the property, the fair market value adjusts to the date of death. So the basis becomes the fair market value at the date of death. They sell the property the next day. You have a zero capital gain. you wiped out $900,000 of exposure, of capital gain exposure. So the revenue rule says a irrevocable trust is not a person, and therefore it does not enjoy the basis. We have to put specific language in a irrevocable trust to be able to extend that basis adjustment. And there are I've seen trusts that were made back in 2000 that did not have these provisions in it and did not have a trust protector. The people who may have real issue of capital gains to their children when they pass away. And we have to try to work our best to try to add and amend certain terms to that. So every trust that I've had, thankfully, has this language to it. So you're either a grantor's trust or an intentional non-grantor's trust. So in a grantor's trust, income is taxable to the grantor, the person who makes the trust. You do get a basis adjustment at death because it's part of the creator or grantor's taxable estate at death. An intentional non-grantor trust is your income tax is taxable to the trust, not to you as a person. There's no basis adjustment at death, and it's not part of the taxable estate. Now, everyone's question is going to be, well, why would I pick an intentional trust, intentional non-grantor trust as opposed to a grantor trust? One of the things having an experienced tax person and a team behind them is we have to weigh a lot of factors. What are the capital gains rate? What are the inheritance tax thresholds? Does it really matter if there's a basis increase? What is it, the trust income tax rate? That will help us determine whether it pays for you either to pay the estate tax, death tax, or not. Whether it should be, if you have $1 million house and you have to go on Medicaid and you pass away, the day after you purchase it, then, there is no real basis adjustment. All of those factors have to be considered. That being said, about 90%, 95% of the average client who comes into my office, we want that basis adjustment, and 90% we do have that grantor trust language. But if you have an irrevocable trust and you're sitting on it and you want an evaluation to determine whether or not you have this issue of capital gains at your death, reach out to me and I'll be happy to do a complimentary read and let you know if you're in trouble or not. I put this up because I get these questions all the time. What's the difference? So a last will is a document that's flexible. You can do tax planning. You can distribute your property. It's usually the less expensive option. So that's who giveth with one hand. The disadvantages is a probate proceeding is needed. It has costs and fees associated with it. New York, I know I say 7 to 9 months, but New York, we've been seeing 18 to 24 months before you can close the estate and distribute all the assets. It also gives notice provisions. You have to find people, and it gives people who may be the bad apples in your family tree an opportunity to contest the will, even if you disinherit them. A revocable trust has the same benefits as a will, except the biggest benefit is it avoids probate. It has a fast distribution of assets. You don't have to wait that 9 to 24 months before you can distribute the property. You retain control. It's a harder vehicle contest. There's no notice provision. There's no probate action. It goes pretty quick as far as that goes. The disadvantages, he who taketh away, is it does not give you asset protection. People are under the myth that it gives you asset protection. A revocable trust does not protect your assets from Medicaid or from creditors. It's an extension of you. And again, we want to make sure that you do not lose any basis adjustment when that trust eventually becomes irrevocable for some reason. And typically you'll have day-to-day, year-to-year administrative costs as well. And now we have the irrevocable Medicaid trust. This is the trust that you want to use for Medicaid planning. It has the same benefits as a revocable trust, except it gives you that asset protection. And we went over the real disadvantages, most hurdles that people have difficulty overcoming is in fact the loss of control and the ability for you not to have use of those assets to your benefit and that loss of basis adjustment potentially that has to be specifically talked about. That's a very typical plan with what goes into a Medicaid asset protection trust. Some other long-term care strategies is a life estate in real property. So I ask every person who I do in the beginning, and I don't tell them why, so don't cheat when I ask you this question if you come in, okay, do you plan on having this to be your forever house? And if the answer is yes, then a life estate in real property is a really good thing. Ownership interest lasts for the lifetime of a person, while a third party is a title owner. So if you have children, you want to put them on title, you certainly can. You hold what we call a life estate. Life estate is an incompleted gift. All of the exemptions that you have now, whether it be a veteran's discount or a enhanced star discount, they all carry through. You are responsible to pay the bills, the taxes, the insurance, utilities. You cannot be evicted. You cannot be charged rent. You're responsible to pay for regular maintenance and the lawnmower and painting. Okay. If there's income, you get that income. As I said, you cannot sell. The title owners cannot sell or get a mortgage without your permission. The title owner is called a remainderman. The remaindermen do have certain rights during the life tenancy, but primarily they sit around and wait till the life tenant passes, and then the property becomes theirs. So the benefits of a life estate in sum, it avoids probate. Ownership immediately passes at the life tenant's death. Tax credits remain while the life tenant is alive. You enjoy the step-up in basis. That's the current state of the law now. Is relatively low cost to set up. And here's the kicker. It has Medicaid advantages. Property becomes exempt after the look-back period. It's a really great way to handle property on certain conditions. So he who give it to the big print, take it the way, okay? There are restrictions on your ownership. You can't sell, get a mortgage without the tenants, without the remainderman saying okay. The property is the asset of a remainderman. In other words, if you have your child who's on title, if they are applying for federal aid for their children, if they go through a bankruptcy, if they have other issues with creditors, now they have an additional asset. There is no step up in basis if it's sold during the life tenant's lifetime, and there is no gain exclusion for the remainderment. So you don't get that $250,000 exclusion if the remaindermen do not reside in the home as their primary house. The biggest issue is in the event that you need to sell the house with a life tenant. Unlike a Medicaid asset protection trust, where that look-back period doesn't restart. If you sell the house, that look-back period will restart if you sell it during the life tenant's lifetime. So if you go through, you're at year 6 after you transfer into a life estate and you decide to move to Arizona, and you sell that house, you've just lost 6 years of planning. So that's why I always ask, is this going to be a forever house? Some other difficulties are the life tenant technically is only entitled to a portion of the proceeds if sold during the life tenant's lifetime. What is the value of the life tenancy based on actuarial tables? And that's what the life tenant is technically should receive, and the remaindermen receive the balance. Okay. I have had clients who have some issues with life tenants where everyone and all the children are all happy and lovey and huggy and Merry Christmas, while they create this, but over time, someone become estranged. There's a predeceased, and now you're dealing with grandchildren. If there's a divorce, remember it's property of that person. It becomes difficult in those situations, so we have to tread lightly. But there are some really great benefits with life estates as long as everyone knows the drawbacks and the risks. That's what that's about. So I want to thank everyone. Looks like I'm a little slightly over time. I said about 45 minutes. It's but just slightly longer than that. Here's my information. I'll be happy to talk to you about it. And hopefully, if you have some questions, I'll be happy to hear it.